Welcome everyone, welcome back from lunch. Good afternoon for those who are in The Hague, and good morning, good afternoon, good evening for those joining us online. My name is Bryce Williams. I'm a legal counsel here at the Permanent Court of Arbitration, and in that role I've acted as registrar in a number of interstate, investor-state and other arbitral proceedings, including a number of disputes with an environmental dimension. I'm also the court's representative to the UN Framework Convention on Climate Change and the Paris Agreement, the Conference of the Parties to the COP, to the UNFCCC and to the Paris Agreement. I'm joined here by our speaker for the session and four distinguished panelists who come from a range of different backgrounds who I'll briefly introduce now. So our speaker for the session, sitting to my right, is Iulia Padeanu Mellon. Iulia is a senior associate at Foley Hoag, where she represents sovereign states in complex interstate and investor-state disputes before the ICJ, PCA, ICJ and UNCTAD tribunals. She also advises states, NGOs and other stakeholders on matters arising before UN bodies and maintains a robust pro bono practice addressing immigration, climate change and gender-based rights issues. As I mentioned, we also have four distinguished panelists. First, we have Mairee Uran, who is a public international law practitioner and arbitrator. Mairee is co-chair of the American Society of International Law's Working Group on ISDS and Climate Change, an adjunct professor at the Universidad Adolfo Ibáñez in Chile, and an observer delegate to UNCTAD Working Group 3. Previously, she led Chile's defense and investment disputes and has also served at ICJ and at White & Case. Second, we have Dr. Marcelo Lozada. Marcelo is a senior lawyer at the Net Zero Lawyers Alliance, where he leads the efforts of the Public International Law Committee, focusing on the intersection of international climate change law and investor-state arbitration. Third, we have Dr. Arman Sarvarian. He's a public international law barrister at Outline Chambers in London and professor at the University of Surrey. He represents states, companies and NGOs before international courts and tribunals, including acting as counsel to the Republic of Côte d'Ivoire in the ICJ advisory proceedings in respect of climate change. He's also a member of ACIL's task force on ISDS that I mentioned before, and in that context is addressing the question of causation in the task force's report. And finally, we have Dr. José Antonio Rivas. José Antonio is adjunct professor at Georgetown Law and founding partner at Xtrategy LLP. As you'll be aware from this morning, he's also a co-founder of the Washington Arbitration Week and the World Arbitration Update. He has acted as counsel for sovereign states in investment arbitrations, individuals and corporate clients in international commercial arbitration, in various matters involving green energies and the protection of the climate system, including environmentally protected areas. He's also acted as arbitrator in matters under the ICJ, ICC and ICGR rules. And earlier in his career, he served as the chief negotiator for Colombia with respect to more than a dozen investment treaties and as a legal counsel at ICJ. Before we get to the substance of our panel, I'd like to thank obviously the organisers on behalf of myself and the other panellists for their kind invitation to address what is a critical dimension of this topic. Of course, I'd also like to thank all of you, in person and online, for joining us for this discussion. I'd also note that our panelists here are here in their personal capacity, and the views expressed do not necessarily reflect the views of their institutions and or their clients. So what are we here to discuss this afternoon? As was set out earlier today, the focus of this session is on the substantive impact of the advisory opinions on merits aspects of international investment disputes, with a particular focus on impacts, how these impacts may play out in the context of energy and mining disputes. And in doing so, we'll pick up on some of the threads that we heard this morning, and that already started to be woven in the jurisdictional section, and in particular on questions of interpretation and systemic integration. As to the structure of our discussion, the session will focus on four key effects of the ICJ's advisory opinions, ICJ and other international courts' advisory opinions, which will split into two parts. The first part will address how the advisory opinions raise the regulatory baseline for states and how they reshape the interpretation of investment protections. And in the second part, we'll address the transformation of investor obligations as well as state defences and counterclaims. In each of these parts, Iulia will give a brief presentation, and then two of our panelists will focus on a particular dimension or issue that arises from that effect. We will have a moment for further discussion and questions at the end of the first part, before we turn to the second part, but we'll also hopefully have some time at the end for questions as well. And with that, I will hand over to Iulia to present on the first part of today's session.
Thank you very much, Bryce, and thank you so much to the organizers for having me and us here today. We're following some very interesting discussions from this morning, so we hope we can continue and expand on some of the themes that you've already heard. The question that we're exploring today, namely how advisory opinions from international courts affect energy and mining disputes, sits at the center of a much broader shift in international law. By way of context, and as you've already heard today, advisory opinions in and of themselves carry significant legal weight, but they are not binding in the same way as judgments in contentious cases. They do, however, help to clarify existing international law. Over the past 2 years or so, 3 separate international courts have issued landmark advisory opinions on climate change. We've already heard much about them, but just to be clear, these have been advisory opinions from ITLOS in May of 2024, the Inter-American Court of Human Rights in May of 2025, and of course, the International Court of Justice in July of 2025. Together, they constitute perhaps the most significant development in international climate law since the Paris Agreement, and they have undoubtedly shaped the legal terrain on which energy and mining disputes are argued. Now, as Bryce mentioned during today's panel, we will explore 4 key effects of these advisory opinions. I will briefly introduce each of them, and then they will be picked up by my colleagues and panelists. First, we will be discussing how the advisory opinions have raised the regulatory baseline for states. Second, we will look at how the advisory opinions have reshaped the interpretation of investment protections. We will then address how they transform corporate due diligence and investor obligations. And finally, we will discuss how they affect state defenses, counterclaims, and the instrumentalization of climate obligations in ISDS, as well as the pathways that are emerging beyond arbitration itself. So to begin, we'll first look at how the advisory opinions have contributed to raising the regulatory baseline. What the advisory opinions have done collectively is basically reset the baseline, or the minimum standard of conduct, that international law expects from states. That baseline is now higher, clearer, and virtually harder to ignore. Across the opinions issued by the ICJ, ITLOS, and the Inter-American Court, we see a consistent message. Climate change is not governed by aspirational commitments. States are subject to binding legal obligations. And these obligations, is very clear, are no longer and not confined to climate treaties. The courts, in their advisory opinions, have made clear that these obligations span treaty law, customary international law, and human rights law, as we have already heard and discussed to some extent in the earlier panels today. And critically, they are executed or implemented through a stringent due diligence standard, measured against the best available science and the foreseeability of harm. Now, this has 2 immediate consequences for energy and mining disputes. First, states are under a legal obligation to regulate the conduct of private actors, including those operating in high-emitting industries. Second, the ICJ went further and explicitly identified fossil fuel production, licensing, and subsidies as an area where failure to act may actually constitute an internationally wrongful act. Now, paragraph 427 of the ICJ opinion specifically states that says that states, not just that states may regulate fossil fuels. In this paragraph, the ICJ was very clear that failing to regulate fossil fuels may itself be an internationally wrongful act. So the baseline has not just been raised, it has basically been inverted. So the question is no longer whether states may regulate energy and mining activities, but whether they are doing enough to meet their legal obligations. Now, the second topic we wanted to cover is how the advisory opinions are reshaping the interpretation of investment protections. Now, there is an inherent tension between investment law on the one hand and climate law. While investment law protects stability and predictability, climate law requires change and adaptation. Now, the advisory opinions, you could say, have sharpened this tension, but have also begun to resolve it to some extent. Most investment treaties require tribunals to apply not only the treaty, but also applicable rules of international law. The advisory opinions have now further clarified what those rules are regarding states' climate change obligations. This is the mechanism, of course, of systemic integration, as set out in Article 31(3)(c) of the VCLT, which sets out that any relevant rules of international law applicable in the relations between the parties shall be taken into account together with the context. The ICJ has now activated this principle in the climate change context in a way that cannot easily be ignored by arbitral tribunals. That has important consequences, in particular for the guarantee of fair and equitable treatment. Investors may find it increasingly difficult to argue that they had legitimate expectations that states would maintain policies that are inconsistent with their international climate obligations. And at the same time, measures that are adopted by states to comply with these obligations are more likely to be viewed by tribunals as perhaps reasonable, proportionate, and non-arbitrary. Now, we have seen this kind of similar reasoning in other contexts. So, for example, in Philip Morris versus Uruguay, the tribunal took into account Uruguay's obligations under the WHO Framework Convention on Tobacco Control in assessing the reasonableness of public health measures. Now, the same logic is likely to carry into expropriation analysis, where non-discriminatory regulation adopted for a legitimate public purpose is less likely to be compensable. We have also seen what happens when tribunals resolve this ambiguity in the other direction. In Rock Harbour versus Italy, a tribunal awarded €190 million for a refused offshore oil license, framing the measure as expropriation rather than legitimate environmental regulation. The advisory opinions may make that framing significantly harder to sustain. And more broadly, the advisory opinions strengthen a range of state defenses, including police powers, necessity, and proportionality. Of course, none of this eliminates investor protections, but climate-aligned regulation now starts from a position of legal legitimacy. Beyond systemic integration, the ICJ also confirmed that climate obligations have an erga omnes character. That is, they are owed not merely between states in a bilateral relationship, but to the international community as a whole. And the mitigation obligations under the Paris Agreement are owed erga omnes partes, that is, by each state party to all other state parties to that treaty. Now, Mairee will explain why this distinction has structural consequences for how ISDS tribunals must approach climate-motivated measures. The temporal dimension adds a further layer of complexity that Marcelo will explore. The baseline against which state conduct is measured is not fixed at the moment of investment, but evolves with the science. And this has significant implications for when the legitimate expectations can be said to have crystallized. Now, I'll pause here and turn it over to Bryce to continue the discussion on these 2 points. Thank you.
Thank you very much, Iulia. And just picking up on one thing that you mentioned, that point about systemic integration that we heard about earlier today, and the role of Article 31(3)(c) of the VCLT, and how that's been activated, that principle has been activated in the climate context. I might throw over to Mairee to explore that issue a bit further. Mairee?
Thank you, Bryce, and of course, thank you to the organizers and to everyone here for your attention. So I know that at this point we have heard a bit about systemic integration and this tool that indeed is incorporated in Article 31.3c of the Vienna Convention of the Law of Treaties. And even though it has been there and it is part of customary international law for a long time, as Sergio mentioned this morning, we have rarely seen it applied in investment arbitrations. And I agree with Iulia that that approach is becoming harder to sustain after the advisory opinions. Now, the foundation of the principle of systemic integration is that treaties are themselves creatures of international law, and that for the treaties themselves to exist and to operate, they need the international legal system. So once this element is perhaps conveyed properly by parties to tribunals, with the force that is required and with the force that now the advisory opinions provide, we might be able to arrive to a different result. And I think what we need to do is to show tribunals that the principle derives from something very basic, and which is from very basic to all lawyers, which is that legal texts only make sense within the context of the system that gives them the authority and meaning. So to ensure a harmonic integration of rules on international law, the reliance on other international law norms must inform states' obligations across different treaty regime, and that needs to prevail over restrictive forms of interpretation. It's not only the ICJ opinion that actually raised the importance of this interpretation tool, but it is also included in the IDLOS and the Inter-American Court of Human Rights opinion. Now, the ICJ used this principle to reject the argument that climate treaties, such as the UNFCCC or the Paris Agreement, constitute a closed lex specialis regime that displaces other rules of international law. And in my view, this rejection is particularly significant for investment practitioners. So the argument that the court was answering is structurally identical to the one made in ISDS cases, which is that tribunals should only confine their analysis to the four corners of the investment treaties, and that states' obligations under other bodies of international law are simply not part of the applicable normative framework. But as I said, I think that the rejection of that argument should apply in both cases. Just as climate change treaties, such as the Paris Agreement, do not constitute lex specialis when assessing the state's obligations in relation to climate change, international investments agreement should not be lex specialis in the context of the relation between states and investors either. In fact, as we heard this morning in the first panel, the ICJ went as far as confirming in express terms in paragraph 173 of the opinion that international investment law is among the rules of international law that may be relevant in the context of climate change-related obligations. By the same token, in interpreting an investment agreement, other relevant rules of international law, including, of course, those that were identified by the ICJ in its advisory opinion, and other general principles of international environmental law, may also be considered applicable in the context of investment law obligations, depending, of course, on the issues in dispute. Now, this does not mean that climate obligations automatically prevail over investment protections. Climate measures, of course, may still be arbitrary, discriminatory, procedurally unfair, or disproportionate, and in this sense, they could also constitute a violation of investment agreements. However, as Iulia showed us very well, the baseline for consideration has changed. A second important contribution of the ICJ opinion that could have an impact on the interpretation of investment treaties is the recognition that obligations to protect the climate system from significant transboundary harm have an erga omnes character, and that obligations under the UNFCCC and the Paris Agreement are owed erga omnes partes. The Inter-American Court of Human Rights also framed the obligation not to cause transboundary environmental damage as one that is owed to the entire international community. And it further recognized the obligation to preserve the equilibrium of the ecosystem in the face of anthropogenic conducts that give rise to irreversible harm as a peremptor minor. But the traditional architecture of ISDS is bilateral: a treaty, two parties, and a claim for breach. When a tribunal will be asked whether a climate-motivated regulatory measure is compensable, it may need to engage, therefore, with obligations whose performance is of legal interest to all states, either under customary international law or, in the case of, for example, the Paris agreements, to the other state party to the climate treaty. And therefore, a measure that implements an erga omnes obligation cannot be assessed in the same terms as a potential interference with investment rights based on a regulatory discretion or simply executing a policy preference. When determining whether a state violated or not a substantive protection of an investment treaty, investment tribunals will need to assess whether the state is acting consistently with an obligation owed broadly beyond its bilateral relationship with the investor's home state that is perhaps owed to the entire international community as a whole, as they involve protections of a global collective good. Now, of course, these opinions do not operate only in favor of respondent states. International climate change law becomes part of the legal environment for all parties. Renewable energy and transition-related investors may themselves invoke the advisory opinions where state rolls back clean energy commitments, apply discriminatory licensing practices, or undermines a coherent transition framework, or even fails to take measures to protect the climate system, and this affects the investor's investment. In those cases, the same principle of systemic integration, the same recognition that climate obligations are legally binding, may support the investor's claim that the state acted inconsistently with both the investment treaty and its broader international obligations. So to conclude, the advisory opinion, in my view, do not rewrite the investment treaties, they do not eliminate investor protections, nor do they decide the future ISDS cases in advance, but they do affect the interpretive method that has been applied to date. They reinforce that investment law is not a self-contained regime, and they moved climate obligations from the background to the interpretive foreground.
Thank you very much, Mairee, for that exposition of the conventional interpretive principles and how they are applied in this context. Taking perhaps a step back now and looking at these interpretive questions perhaps from a more conceptual or theoretical lens, I'd like to throw it over to Marcelo, who's done some very interesting research on this point, and I'd be happy for you to share it with our audience.
Thank you very much, Bryce, and thank you to the organizers of WAU for the invitation to this very interesting panel and this conversation. Yes, I think I might take a little step back to move forward, hopefully, in the conversation in the context of today's conference, by looking at some conceptual issues of why we are experiencing these debates and why climate change, from a conceptual perspective, raises some legal questions that prompt or might prompt arbitrators in the context of existing cases to engage with distinct legal questions that are perhaps not necessarily typically exposed to. So I will start by describing climate change as a complex phenomenon, which we all know, but which some policy experts describe as a super wicked problem or wicked problem in policy literature. And I've narrowed down some of the characteristics of climate change to 4 relevant features that explain some of the conceptual issues that I will discuss. So I will go through 4 characteristics of climate change, just to wrap it up, and I will discuss the potential implications of each of these features for the way arbitrators interpret doctrines in the context of ISDS cases, so in particular how they interpret substantive protections, which is obviously the topic of this specific panel. So the first feature I'd like to discuss is multivalence. Multivalence means, in a nutshell, that climate change and climate-related measures, climate change governance, is susceptible of being framed in multiple competing ways. We see it in multiple cases of climate litigation around the world. We've seen constant clashing between the way issues around climate change are being framed. So I'll give you a very specific example from the Hacienda Electrica case versus Germany. I've gone over the claimants memorials and counter memorials, and you can see how the parties provide different, competing framings of the regulation, the phase-out regulation who is being challenged in this case. So on the one hand, the claimants frame this measure as a drastic regulatory change. They use the ICER foresight sort of case law to claim that the phase-out measure is a drastic change, is inconsistent with the previous regulatory framework in which they allege the ETS was the only measure set into place to reduce emissions in Germany. And they used the period from 2008 when the investment was made to the period of 2017-18 when they were operating with normality and before the coal commission was installed in Germany, was set up. And then so that's one framing. The other framing from the respondents in this case is that there was a continuous foreseeable regulatory evolution going all the way back to the Kyoto Protocol, to the Paris Agreement, which led up to the phase out of coal in the country. And you can see how these competing framings are really substantial for the way these dispute will be adjudicated, right? Arbitrators will have to discuss both framings and will have to decide, okay, am I discussing how there was a constant regulatory evolution that might be an expression, a legitimate expression of the police powers of Germany, or am I discussing how the FET clause protects the investors against a drastic change? Because the claimants in this case are not asserting a legitimate expectations violations, because they don't think perhaps there was ground for such a claim. They're asserting that there was a radical regulatory change which the FET clauses protected them from. So you can see this is a clear example where the frames, the way that these disputes are being framed matters significantly, and so climate change is susceptible of that. And we've seen it in climate litigation in other areas of practice as well. The second feature that I would like to briefly introduce is polycentricity, which basically means that climate change resolves from a vast web of interdependent actors, a vast web of interlocking sources of emissions over a large period of time, which I'll discuss in a second. And these naturally has implications, or has had implications for the last 2 decades for causality and for the way damages are also being framed in adjudication, right? And this is something that we've also explained in the context of Hacienda Electrica. Again, there is contestation between the parties as to, if any, what would be the quantum of the damages, which is something that we'll be discussing in a later panel. But I just want to leave it there. And this polycentricity also matters for the way the state's margin of appreciation is framed, because climate measures result from a massive web of trade-offs. Climate governance is about trade-offs. You have to compensate and compromise between energy production, energy security, political economy, and therefore that heightens the the leeway granted to states in terms of their margin of appreciation. This is something that has been recognized, for example, in the recent ECHR case law in Klima Seniorinen, where basically the court decided to grant significant leeway for the measures that are implemented, the scrutiny over those measures, which is something that Professor Surgeons also mentioned earlier. We provide more leeway to what you do, but perhaps, at least in the context of human rights, we provide less leeway as to what you have to do, which is naturally at least achieve net zero by 2050, or at least try to comply with a 1.5 to 2 degree pathway. So these are some issues that are already being seen in the context of existing cases. The third, third feature is the spatial dimension, the spatiality of climate change. Climate change is naturally geographically unbounded. It happens both domestically and internationally, which is why we are having this this big discussion about the international law domain. Because in respect to other environmental problems, we have more discrete international legal frameworks. We have perhaps bilateral understandings between of transboundary harm. But in the context of climate change, we have international legal frameworks that regulate and to some extent, impose some obligations on states with respect to every other state, as my colleagues rightly explained. And finally, the fourth but not least important characteristic of climate change is the issue of temporality. Climate change unfolds over very long timescales, longer than human timescales and longer than the typical timescales of legal thinking. And this creates a structural mismatch between this physical reality of climate change, which is how GHG emissions accumulate and affect our climate, and the way we operate in legal thinking, and also the human activities that give rise to these emissions. And in here, just to wrap it up, there are some discussions around the temporal dimension. As I mentioned in my example of multivalence in the context of Hacienda Eléctrica, you can see how the estate is providing a temporal framework, which is 30 years, 30 or so years, while the claimants are providing a different timescale, which is 10 years. 10 years in which they thought there is a stable regulatory environment, and this is what matters from the understanding of my protection under the FET clause. And the state is saying, you cannot take this snapshot, you have to take a longer understanding, which is at least 30 years, which is a constant evolution of my regulatory framework, also in a dynamic understanding of that. So finally, I'd just like to open the floor for any questions in this regard. I'm happy to discuss this further. I personally have advocated for more transparency and humility in the way we approach these doctrinal issues, and also we approach the institutional dimensions of the way climate change is being adjudicated. I think tribunals are going to be confronted with tricky legal questions that they're perhaps not used to, and I hope that they will develop a sense of sophistication and sensitivity to some of these concepts to provide adequate legal responses to the legal questions before them. And with that, I finish my presentation. Thank you so much.
Thank you very much, Marcelo. But before we open up to the floor, and we will in just a moment, I will turn over to Iulia whether she had any initial reactions or comments on those interventions.
I guess just a brief reaction or thought as Mairee was talking, I guess. And I hope I'm not sort of getting ahead of the conversation, but prior to these opinions and sort of the difficulty that states had found them in was kind of what we've talked about, I think, in some of the panels today, and we know as sort of like this regulatory chill, where states felt like they were kind of stuck between this rock and a hard place, between not being able to, change the regulation or act on certain things that they felt were necessary. And so now with the AOs in place, perhaps what we're seeing and what we're going to see is states having a bit more of a hook or, an added sort of evidence for some of the changes that they're going to take, or some of the regulatory changes that are going to happen. But I also think, and this came up, I think, in one of the panels earlier, and I apologize, I don't remember exactly who it was that sort of mentioned this, and I thought it was an important point that, although states I do think are going to be relying on the advisory opinions to sort of explain some of the regulatory changes, and I think investors are, kind of well placed to expect that the regulatory, landscape will not be static and will change. I think investors in states sort of are not as opposed in their views and in what they want as maybe it comes out in some of these discussions. I think a state will very much be incentivized by wanting to create a positive atmosphere for investment. I don't think states are all of a sudden going to start regulating in a sort of incoherent or crazy manner. I think it's just, they're still going to have to act reasonably. There are still going to be protections in these investment treaties that are going to, shape the way that they are changing regulations, even though, let's say, there is maybe more now basis for not keeping static over the next 30 years or so the regulatory landscape in their particular societies. So that's all I'm going to say, and I'll turn over the floor.
Fantastic. And before we have any questions, any reactions from Arman, Jose Antonio?
Thank you, Bryce. And thank you for the comments, both of Mairee and also Marcelo. On Mairee's point, I'm absolutely in agreement with the notion that although public international law and the Vienna Convention on the Law of Treaties provides that there should be an integrated interpretive approach, the truth of the matter is that as might be confirmed from some research of an LLM here present, is that investor-state arbitration tribunals might refer to Article 31(3)(c), but seldom, or at least in a very few occasions, really rely on the universe of public international law. So sometimes tribunals might even cite it, but the development might be limited. So this is an invitation, or beyond of an invitation by the World Court to investor-state arbitration tribunals to go beyond that. So that's one point, and I thank Marcelo for sort of educating at least me on some of the principles and realities of international environmental law. And as to the last comments on regulatory chill, I had that question asked a few days ago. In fact, I believe that the invitation is quite the opposite. It's actually to, by the way of duty of due diligence, the obligation is to do a thoughtful regulation to prevent climate change harm ultimately. So we would be seeing the opposite. On whether there would be crazy or not regulation, I do seriously think that it really depends on a government by government basis. I've seen some invitations to governments as, and I would say it, I don't know how else to say it, but as nonsensical as, terminate all the treaties, which would actually invite investor disputes in a rush, which would be very harmful to that particular state. We've seen other examples of the opposite, actually lifting all the, or relaxing all the limitations to, or all the protections to environmental climate change protection. So I would not be that optimistic, but I'll stop there.
Great, thank you very much. I'll now turn to the floor. If we had any questions for our panel. Yes, well, I'll bring you with the microphone. 1 second. And if you could just state your name and your affiliation before you ask a question. Thanks.
Good afternoon. My name is Geneviève. I'm the CEO and founder of the Global Climate Resilience Intelligence Network, and I am a subject matter expert on dealing with climate science, international ESG regulation policies, and yeah, so my first question is, or my comment at the same time, is that question or the comment that spoke to the interpretation of climate science, right? And so specifically, the UNFCCC treaty said that institutionalized periodic review needed to be informed by the International Panel on Climate Change assessment cycles, right? So what that would explain is that the International Panel on Climate Change assessment cycles are what are in fact, associated with a legally binding treaty, right? So that climate science in those reports would be what I would be pointing to. The next thing is that the Paris Agreement specifically states it requires financial flows to align with a low carbon pathway. What does that mean, right? So if it's been ratified, right, that means that I, as a state, have said that it's material, and if it's in fact material, and I am a fiduciary, because I am a state that deals with securitized products, whether it be municipal bonds, treasuries, things like that, right, that I have said that everything will require financial flows to align with low carbon pathways. With that being said, I'm a little bit confused why one country or state in comparison to another would state that the climate science that is communicated in the International Panel on Climate Change is not in fact what they believe to be true, when it is in fact associated with a legally binding treaty that I have signed, or the Paris Agreement, right, that has been ratified. And by the way, the nationally determined contributions, when they get submitted, they get attached to the UNFCCC treaty, which is legally binding. So it means that the nationally determined contribution, which is their decarbonization pathway, is legally binding as well, in accordance with the climate science that I used for that. So I guess my question is, how is the climate science confusing, right, when it's communicated in the International Panel on Climate Change reports?
Thank you for that question. I'll take one further question before we turn back to the panel.
Thank you. Monica Ferretinta. I wonder whether anything can be whether you can build a parallel or you can extract something from the earlier tobacco industry cases by way of comparison when it comes to how investments were assessed back then, and obviously there were policies that were initiated that led to a number of claims.
Fantastic. So we have two questions there, one on climate science and one on the tobacco cases. Does anyone want to jump in?
I'll take the first one, because I think it's necessary to differentiate the task of tribunals when doing the task of legally interpreting the text, the investment treaty in investment tribunals, with how scientific evidence is assessed in a case. So those are completely different matters. What we have been discussing to date is how you should interpret the substantive protections, and this is where systemic integration comes in. Now, as to the use of scientific evidence in ISDS, there have been, from my perspective, different ways in which tribunals have assessed scientific evidence, obviously not relating to climate change, because as you all know, we haven't really had cases where tribunals have engaged with the substance of climate change issues, but that have either looked at questions of health, as for example in the Philip Morris case that Iulia mentioned versus Uruguay, or others in connection with environmental questions. And tribunals have basically used three different methods. One is what I'm going to call the international context review, which is what happened in Philip Morris, which is the tribunal said, we are not going to require, in order to determine that the measure taken by the state is indeed proportional, based, bona fide, that follows a legitimate public welfare objective, et cetera, we are not going to require that the country provides specific scientific studies. It is sufficient that, for example, international bodies, just as the World Health Organization or others, or PAHO, the Pan American Health Organization, in the case of Philip Morris, have done it, and that is sufficient for us to determine that the state actually had a scientific basis to do it, and they didn't go into the merits of that science. There have been other cases where they did do that, and I think Leanne mentioned that this morning, and I think it was in connection to Metalclad, and where the tribunals have actually taken a substantive or merit-based review, and they evaluate the scientific conclusions presented, and that might be more complex. But perhaps one way in which this could work is by a process-based review, and this is where what the tribunal does is assess the methodology that has been used by the state, and just basically try to assess the decision-making process rather than the outcomes. And in that way, the tribunal is not second-guessing the decisions of the state. There's more, perhaps a better application of the margin of appreciation, even though this is a concept that sometimes is disputed as applicable in investment arbitration. But perhaps a process-based review is something that could assist in making sure that scientific evidence is there, but without tribunals second-guessing the state's decision on the basis of scientific methods. But I think that it's important to distinguish between the legal interpretation and the use of scientific evidence. I'll leave someone else to respond to.
Sure. I think, well, I mean, we got a bit of both answers to both questions. If we have any very short reflections before we move on to the next part.
Yeah, I think when it comes to scientific evidence, there are different sources that have different relative authoritative value. So I think the IPCC has so far proven to be the most convincing in climate litigation worldwide, a bit less so in the US, but everywhere else courts have significantly engaged with IPCC and have to some extent taking the assessments at face value simply because states agree to these reports word by word. There are representatives of the states that have to agree to the statements in those. Therefore, it seems as a source of consensus of international science. It's different when it comes to other sources of scientific evidence, when it comes to academic papers and so on, because those can be disputed and sometimes are. But interesting, for example, in the Hacienda Electrica case, the German state did rely on the IPCC reports. I've just looked it up quickly, and they used the IPCC reference 162 times in the counter memorial. So they're heavily relying on it, again, as the framework of this is a consistent regulatory evolution that is accompanied by scientific developments. Therefore, I'm just kind of following up on the way this whole ecosystem works. And they also rely sometimes on domestic agencies, domestic climate change committees, for example, in the UK, in Germany. In this case, they also had the Code Commission, which provided an independent expert report. So there are different sources at play here. And I won't comment on the second question because I think that's been partly addressed.
Fantastic. Thank you, Marcelo. And now turning to the second part of our panel on investor obligations and also on state defences and counterclaims, I'll turn back to Iulia to briefly present these issues.
Thank you very much, Bryce. So turning to the second set of issues and sort of the third point that we wanted to cover today is how the AOs are transforming corporate due diligence and investor obligations. So the AOs don't just reshape the obligations for states. They also have important implications for how investors design, assess, and defend their projects. And increasingly, they also raise questions as to whether investors themselves bear obligations under international law. We heard a little bit about it this morning. And if so, if they do bear these obligations, in what way? If state obligations are measured against best available science, which we're just discussing, then corporate risk assessments can no longer assume that the regulatory framework at the start of a project will remain stable over time. So as a result, I think we're going to see 4 shifts. The first would be dynamic regulation. And again, this is something we've sort of discussed in this panel and throughout the day. But permitting is no longer a one-off exercise. Long-term extractive projects will need to adapt to evolving science and policy. There's also going to be value chain accountability. The focus is no longer limited to a project's direct emissions, but extends across its life cycle and includes the emissions generated when the fuel is ultimately burned. There's also human rights integration, and particularly this is the case in the mining sector, where the Inter-American Court of Human Rights has emphasized the right to a healthy environment and the importance of community participation. And the Paris Agreement as a due diligence baseline. The nationally determined contributions that each state has submitted under the Paris Agreement constitute a publicly available roadmap of sorts of the regulatory trajectory that investors are entering. So a project that launched in post-2015, when the Paris Agreement came into force, is in a high-emitting sector cannot plausibly claim that climate regulation was unforeseeable. So the practical implication of this is straightforward. Projects must now be designed not just to comply with the current regulations, but they must remain defensible as the regulation evolves. Now, I know Arman will develop further what the current state of investor-state practice actually looks like in terms of how investors' duties and due diligence obligations are being argued. And the 4th point we wanted to cover today is how AOs have impacted state defenses, counterclaims, and the instrumentalization of climate obligations. So the advisory opinions may shape the landscape of how climate obligations are used as legal instruments in ISDS by both states and investors. So on the state side, the AOs give a principal basis for several defensive arguments. For one, that climate-aligned measures are required by binding international law. Second, that a respondent state's conduct should be assessed against a stringent due diligence standard, and that the necessity and police powers defenses are strengthened when states act in good faith to discharge their climate obligations. Now, the advisory opinions may also encourage greater recourse by states to environmental counterclaims. Now, we've already seen something like this play out in cases like Perencova versus Ecuador, where Ecuador was awarded $54 million for environmental pollution caused by the investor. We've also seen this in Urbasser versus Argentina, where the tribunal accepted jurisdiction over a human rights-based counterclaim and, notably, considered for the first time whether investors themselves might bear direct obligations under international human rights law. Now, the ICJ's clarification of binding climate change obligations may spur further counterclaims grounded in environmental and human rights obligations. At the same time, it's worth noting that only a small number of treaties directly impose ESG or environmental obligations on investors, as Jose Antonio will further discuss. Because investors are not directly bound by customary international law, absent specific agreement, this shapes how far counterclaims grounded in international law, rather than domestic law, can reach. And moreover, as Arman will elaborate, practice to date shows that counterclaims are generally exceptional. Nevertheless, they may still become a more frequently used tool in states' arsenal defending against investment claims. Beyond state defenses and counterclaims, it is worth noting that the advisory opinions are not a one-way street. The same principle of systemic integration that raises the bar for fossil fuel investors can work in favor of clean energy investors, where the states roll back renewable commitments or reverse clean energy frameworks. Jose Antonio will also elaborate further on how these tools operate in practice, including state defenses grounded in the ICJ opinion, the conditions under which counterclaims can succeed, and pathways beyond arbitration altogether. So the role of mediation and amicable settlement, and the growing pressure towards investment treaty renegotiation, which some constitutional orders may require. So in closing, the advisory opinions do not create new law, but they do clarify existing law in a way that raises expectations across the board. And as this panel has already shown and will continue to discuss, there are significant live questions about how the clarification translates into practice, questions on which reasonable specialists, as we've already seen, disagree. For states, that may mean regulating more and more carefully, and for investors, it will mean recalibrating expectations about stability. Climate obligations are no longer peripheral. They are central now to how energy and mining disputes will be argued and decided. And these questions that we are addressing today are not purely theoretical. ISDS itself is under pressure to adapt, from UNCITRAL's ongoing reform process to the OECD's proposed climate carve-out for investment arbitration. How arbitral tribunals engage with these advisory opinions in the coming years will shape not just the outcomes of those individual disputes, but the legitimacy of the system itself. And the pressure extends beyond arbitration alone. The same legal shift that raises the stakes in ISDS is also driving states towards to mediation, amicable settlement, and in some cases, as I mentioned, treaty renegotiation as a constitutional necessity. So thank you very much. I'll stop here, and I look forward to the rest of the discussion.
Thank you very much, Iulia. Picking up on the third point that Iulia discussed on investors' duties, I might hand it over to Arman to explore the most recent developments in this area.
There have been, in my estimation, but 4 climate cases in the ISDS field to date, all of which have concerned the phase-out of coal in various jurisdictions. The first in chronological order was Westmoreland versus Canada concerning the phase-out of coal in the province of Ontario. That was thrown out of the jurisdictional phase, but I would still count that as a climate case, notwithstanding that we did not see how it would shape at the next phase. The second, which are 2 cases, formally speaking, but could be counted as one for present purposes, are RWE versus the Netherlands and Uniper versus the Netherlands. Those were discontinued without an award being rendered on the merits, though the pleadings are public. And the third is the Hacienda case, which is pending and was mentioned earlier. As I was lead counsel to the applicants for PO8, the NDP applicants, allowed me to clarify that they were not a group of academics. That was the first, those were the first applicants. Rather, there were 4 NGOs, 2 of which are based in Germany and 2 of which are based in Switzerland, and also allow me to clarify that the tribunal, at least in PO8, did address the second of the 2 issues that were mentioned on the duties of Switzerland, specifically because one of my clients had been involved in the 2016 referendum that underpins the facts in that case. However, there are 4 cases because the first or critical point that I would make is that it very much depends upon the case strategy and approach taken by the respondent in a particular arbitration in the first instance. Obviously, the arbitral tribunal's estimation in the first award on climate change and ISDS that we anticipate will be independent of that, but if the respondent not make the arguments in the first instance, it's unlikely that the tribunal will raise it of its own accord. We can take as examples Rockhopper versus Italy 1, in which Italy did not raise it as a climate case for the exploration and development of offshore oil. In my estimation, not least because the facts did not support it when one looked back to the actual conduct of the environmental impact assessment, which did not really look at greenhouse gas emissions, certainly not downstream emissions. Similarly, Klesch versus European Union, Germany and Denmark, they are on record in one of the POs as not considering that to be a climate case, notwithstanding the references to decarbonization in the windfall profits tax EU regulation. And I note that there's a case pending in this institution of Petrogas exploration. I'm not aware of the position taken by the respondent in that pending case. And then we have Lansdowne versus Ireland, another new case in which we don't yet know similarly the position of the respondent. So all of which is to say that if we are to consider, for example, the interpretation of investment agreements or other instruments according to international climate law, the issue has to be raised by the respondent itself in the first instance for it to even become relevant, notwithstanding what might have happened in the factual context. I would classify climate cases within the ISDS field in 2 groups. The first would be retrospective or backward-looking claims. That would be the Coal Phase-Out Act, for example, various coal phase-out legislation claims that I mentioned, in which the question is the cost proportion in the context of an energy transition to be borne by investors versus the state, simply put. And there, I say cost proportion, and it varies according to the specific sector or project, and very much taken as a sectoral level in the cases to date, because it's not an exclusive either-or proposition. It's a question of how much, essentially, are the respective stakeholders to pay. And then the second group of cases would be prospective or forward-looking cases. That is to say, is there a right of an investor to pursue new fossil fuel projects or to develop new fossil fuel projects in the face of a denial, annulment, or revocation of a license or other enabling instrument by the host state? And here the question of downstream emissions and whether they are to be considered in the scope of an environmental impact assessment is absolutely central. In this group of cases, we might consider ZEF Investments versus Australia 2, pending in this institution. That is at the jurisdictional phase, and we await an award on that. Woodhouse versus United Kingdom, an ICJ case, in which when one looks at the underlying judicial proceedings that prompted the claim, that's very much central to that. And I would also, noting this is a panel about the advisory opinions in the plural, I would also note the advisory opinion of the EFTA Court in Greenpeace Nordic versus Norway, as well as the judgments of the European Court of Human Rights in Greenpeace Nordic versus Norway concerning separate oil field developments in Norwegian waters, yes, brought before non-arbitral jurisdictions or not out in ISDS, but very much, if one look at the substance, central to our substantive discussion today. So in that sense, when we're looking at those two groups of cases and the tactics and positions that respondents might develop, taking into account the limited ISDS practice that we have to date, really Hacienda and RWE Uniper, counterclaims have been limited historically in ISDS practice, but there are but one approach or one tactic that can be taken. Certainly one can consider arguments on liability and the interpretation and application of the standards themselves, which actually could have a far greater financial effect depending upon how it's argued and ultimately decided. And also arguments in mitigation, looking ahead to the next panel, such as contributory negligence. So there are different tools available to respondents to frame the issues. But on the counterclaim side, we do have two cases of successful counterclaims brought by Ecuador. Burlington was the first, and the second was Perenco. To give a sense of the scale, there was 380 million US awarded against Ecuador in Burlington. Ecuador brought a counterclaim of 2.8 billion US, but that was for breach of national environmental law incorporated via contract into the investment relationship, with $42 million awarded for, amongst other things, pollution of groundwater, contamination of soil, and failure to implement oil field restoration of the natural habitat. So it is a tactic that can work, or has worked in the past, but there are examples of failures. We have Urba versus Argentina, for example, in 2016. And there the counterclaim was a failure to invest in the context of a sewage and water concession in the city of Buenos Aires into infrastructure. And there the issues were framed, interestingly for our purposes, primarily as a human right to water or human right to health issue on the part of Argentina. The arbitral tribunal did not ultimately import, so to speak, the human rights law into their interpretation of the investment agreement. So that's an interesting, if you like, presented as a counterclaim, but also potentially as a liability tactic, an interesting point of comparison. So, so here when we see how these issues might frame in terms of alleged breaches by the investor of certain obligations arising principally, I would suggest, under national environmental law. We could see arguments potentially brought under Article 42.1 of the ICJ Convention, applicable law, including national climate change laws. That is yet to directly feature in an arbitration to date. But if we look at the facts of underlying judicial proceedings that have underpinned the pending cases that I've described, see in particular the advisory opinion of the Land Court of Queensland that underpinned the decision of the Ministry of, in Queensland to deny the license for the production and exploration of coal mines in ZEF2 versus the ZEF2 case versus Australia, a very sophisticated analysis on the part of the Land Court of the climate change obligations of Australia as a specific individual state party, downstream emissions being taken very much into account, and I note pending proceedings before the High Court of Australia on that very question of downstream emissions. And so there we might see, in the context of the national judicial proceedings that underpin the very complaint brought by the investor, an interpretation and application of national climate law, but taking into account the international standards, including the advisory opinions that we are discussing. So if you like, an indirect way in which this comes into play, but it could be cited directly in the arbitration itself. Similarly, we can also see in the context of contracts, the possibility of arguments being brought for breach of contractual provisions that incorporate national law along the lines of the Burlington and Parenco case that I mentioned, as well as contributory negligence. And there have been occasional examples of this under Article 39 of the 2001 articles. That's primarily a mitigation point, but if, assuming there has been a breach on the part of the host state of the obligations owed to investors, that could potentially be a way to reduce liability. But as a cautionary tale, see, for example, CMN versus Romania, in which the position was taken, that is a international commercial claim brought before the International Chamber of Commerce, in which Romania was found to owe the investor, so to speak, or the counterparty, 34 million for environmental cleanup costs arising from oil wells decommissioning and other legacy environmental costs. So in other words, it could backfire depending upon what was actually negotiated in the contract and agreed, assuming there is an investment contract. Finally, as a potential respondent tactic or approach, we have seen an example of this. We can consider specific agreements, for example, at the sector level. In the RWE versus Netherlands case, the respondent invoked a power sector agreement of 2008, concluded with all the various investors, including RWE, in which there were obligations, so said the respondent in the proceedings, obligations undertaken to, amongst other things, convert to biomass from the year 2030 onwards, as well as to seriously develop carbon capture and storage in order to mitigate the emissions arising from the Eemshaven plant. And the Netherlands argued that RWE had ceased to develop CCS from 2011 onwards, and by its own admission, the claimant had not converted the plant into biomass. So there we can see an example. Similarly, if you look at South Lakelands Trust, the Woodhouse, Friends of the Earth and South Lakelands Trust and Secretary of State for Levelling Up, the judicial proceedings underpinning the new suit against the United Kingdom, the approach taken by the High Court of Justice there, by the Commercial Court in application of national climate law of the United Kingdom. There, on the one hand, an invocation by the investor to support a net zero mine claim of voluntary carbon credits, which was not permitted under the UK Climate Change Act, and on the other hand, similarly, a failure to develop carbon capture and storage. So there are various ways in which these issues can come in, not only with respect to the underlying, if you like, judicial proceedings, assuming they are there themselves at the national level, that prompts the complaint in the first place, but then also in the arbitration itself, depending critically upon the position taken by the respondent in the particular arbitration, on which there are many different factors. And one of those factors might be, for example, if there are pending climate litigation cases against the respondent before its own courts. And so it needs to ensure that it's taking a consistent position if, for example, it is resisting certain climate claims before its own courts, and in parallel, bringing climate arguments in a pending investor-state arbitration over many years.
Thank you very much, Arman. To keep exploring this topic in particular on the fourth question, the question of state defenses, counterclaims, and the instrumentalization of climate obligations, I'll turn now to Jose Antonio.
Thank you, Bryce, and thank you, Arman, for your remarks. What I would like to do is somehow refer to the alternatives that states and investors may have in light of the fact that there are climate change international obligations as identified by the ICJ. So the way I would like to refer to it is there being a logical assumption that the climate change obligations would lead in principle to instrumentalizing it as defenses. Let's say we have a set of obligations, including the obligation of due diligence to regulate, to prevent climate change harm, or to protect the climate system. And then to recall, we also have the obligation to not to incur in transboundary environmental harm. And by the way, I do think that and incidentally, I do think that the ICJ went somehow may have expanded or not expanded, but at least interpreted in a very gas emissions, greenhouse emissions of gas compliant. And what do I mean by that? If you look into, for instance, the case between Uruguay and Argentina, where transboundary harm was actually referred to, or if you look into the claim of Ecuador versus Colombia for pesticide pollution, those are cases that refer to transboundary harm between neighbors, geographical neighbors. But here, the ICJ identified that severe transboundary harm can actually happen by greenhouse emissions caused by one state. Let's put a state in the North Pole, not to name any, and their lack of tending or compliance with the international obligations on climate change may actually harm a state in the Caribbean, and that may be seen as transboundary harm. So we're not only referring here to harm between neighboring states, but on a global scale, which is actually, at least in my eyes, remarkable because that was actually clarified, and those that opposed some of the views identified by the ICJ there were arguing that there was lack of clarity, and I think that there is clarity in the ICJ advisory opinion. So there's that obligation, and of course there's the obligation of cooperation, which clearly is no longer an obligation of soft law, but it was identified that there is a stringent obligation and a must to cooperate. So with that, I refer to the possibility of there being, for instance, changes or terminations of licenses, and the state may use the advisory opinion or the obligations there in identified as a defense as such. We have as a support, in addition to the main opinion, we have also separate opinions or joint separate opinions by Judge Cleveland as well as by Judge Bandari, indicating that the whole due diligence is not to be done ultimately concerning fossil fuels only at the sale level, but at a very, very early stage. So what we see here is a whole sort of adaptation or call for intervention throughout the chain. Whether or not that is something sustainable and positive geopolitically, that's another question, which is something that of course, Professor Freddie referred to earlier on. But that is the invitation by some of the judges there. So we can see that as a defense of some of the regulatory overseeing by the states. Now, moving along, there's also something quite important in the ICJ opinion, which is a specific reference by the ICJ to connect, on the one hand, climate change obligations and the rights of communities affected, specifically indigenous peoples, and pretty much this is not new, but what is new is that there is a connection between those communities being affected, specifically identified as indigenous peoples, but let's be clear that in the words of James Anaja, former rapporteur for indigenous peoples under the UN, at least he believes that it's not something of a right only limited to indigenous peoples, but any communities that would be affected. And that those rights should be taken into account when related to climate change as well. So that's an additional aspect that we have to take into account. Under all those type of cases, we can see the defense of the state being sort of strengthened, and that might come. One point that Mairee referred to is the policies may pass muster if, of course, they are done in a non-arbitrary or non-discriminatory manner. If you have clear discrimination between two communities, for instance, or if you have clear discrimination between certain fossil fuel companies, then tribunals might not simply buy the argument. So that's one set of instrumentalization. The one other instrumentalization of cases is the one related to potential cases brought by investors that would be investors in green energies or somehow efforts to protect the environment. On that, I think it's important to refer to a few cases that have been thus far not successful, but nevertheless we start seeing at least attempts to use the system for purposes of green energy protection or climate system protection. One is a case, Allen versus Barbados, related to an environmental sanctuary in Barbados, and the investor basically, or the alleged investor, indicated that he had invested to protect a reef sanctuary, and the tribunal heard him and found that the evidence was lacking. But the issue is, at least in my eyes, investment treaties are not left or right. They can be used for purposes of also of transition in climate change. Another case that I find very relevant is Koch versus Canada, where emissions allowance were purchased by Koch Industries, and the question there was quite obvious because the applicable law was that of Canada on whether or not purchase of emission allowances constituted property and therefore constituted investment. The tribunal found that under the applicable law it did not. But what you start seeing here is a question as to whatever transaction you're doing, could that be also framed as investment under the treaties? And then that's really the question. Another example that I can give you is a few days ago, I learned that there had been a public debt swap between some institutional investors and the Republic of El Salvador. Debt swap for protection of the environment. So the question there, is that an investment? Again, and let's keep asking the same question. Are green bonds investments or not? If you ask that question under BITs of the Republic of Colombia, I can tell you that if they're issued by the government, there would not be, because sovereign bonds are excluded from the definition of investment. But if you go to some of the neighboring countries, Argentina, for instance, you remember the cases of Argentina concerning bonds by Italian shareholders. Well, they might be. So the message here is, as you know, considering the ICJ advisory opinion, there is a question of, do these treaties or need to be somehow thought again in light of the advisory opinion to actually foment the climate change transition and the protection of investment in that transition. So that's one question. On the issue of counterclaims, there's Arman, you know, thank you for referring to the facts. I just want to make, ask the question whether the advisory opinion has made any change or not. Or does it constitute an incentive to more counterclaims? And I would like to review the logic behind counterclaims. I mean, the counterclaims actually have two sticking issues. One sticking issue is a jurisdictional one, and another one is a merit-related issue. The jurisdictional one, the tribunal has to ask itself whether or not, under the language of the treaty, the state has given its consent to be sued through or the investor has given its consent to be sued through a counterclaim. Some of the language of the treaties provide, for instance, that both parties agree to submit themselves to a claim by the other party. And that language would be an ideal language for a counterclaim, because either party can be the claimant, the state or the investor. But some treaties provide that an investment treaty claim may only be submitted by the investor. If that is the language of the treaty, then it doesn't allow, in principle, to have a counterclaim submitted by the state. So that's where you have trouble. And you have cases where such language exists, and tribunals have not found that they have jurisdiction. So that's a jurisdictional question. When you go beyond that, and in the Rivas case, which many, including me, saw as a groundbreak, at least jurisdictionally, you say, wow, they went beyond jurisdiction. Not only that, the tribunal actually took a very integrated approach. Article 31(3)(c, they applied public international law in a broad sense by referring to human rights as part of public international law, and therefore as part of the applicable law. So groundbreaking. Yes, we can hear you, but when we get to the merits, now let's see if the concessionaire was bound to provide the access to water. And then when it looked into the treaty, it found no language within the treaty where it could conclude that the obligation to provide access to water was transferred from the state to the investor. And therefore, that's where it stopped. It didn't have the language to rely upon to conclude that the obligation was the concessionaire's obligation. So here, the truth of the matter is that the advisory opinion does not provide that the customary obligations or the treaty obligations are obligations transferred to private parties. It does not. So through customary international law or through treaties, as most of them stand, the advisory opinion cannot transfer those obligations, and it does not. So does it move the needle? I would posit that a little bit, to the extent that it does oblige the states to regulate, and that regulation has to be respected by the private parties. So that's the way it does it. Exceptionally, we might have less than 10 treaties which actually provide that some investors are bound to comply with environmental and human rights and ESG obligations. Example, Morocco, Nigeria. Example, the protocol of the African FTA, which is not still in force, but they provide direct obligations to investors. And in 1 minute, I would like to connect all this to two more things. Arbitration, despite those that practice it, investment arbitration, is not the only dispute settlement that can take place. There's many exchanges, mediations, amicable settlements that may be taking place now or may be fostered through that climate change transition. That was the first point. And the last point is the issue of treaty renegotiation. One aspect, for instance, that I share with you, and this is not an exclusive situation, Justice Natalia Angel Cabo from the Constitutional Court of Colombia a few days ago shared with a whole audience that the Paris Treaty was part of the constitutional bloc, which means of the Constitution of Colombia, which means that if that treaty is part of the Constitution of Colombia, then immediately there's a notion that for constitutional compliance, there needs to be at least a conformity between existing treaties of that country and the Paris Treaty. I do not think that that is an exceptional situation. I do think that that sort of heightened requirement might be more pervasive than we think, and therefore renegotiations are at the next door.
Fantastic. Thank you, Jose Antonio. That's almost all of our time, but just I wanted to make sure that we had some opportunities for questions from the audience. If there are any burning questions, I see 2 burning questions, and I'll if we can try and make those questions quick, that would be fantastic, and we can get some quick responses from the panel. Sorry, if you could just pick up those. Yeah, thank you.
Hi, thank you for a very interesting panel. Uran Stoger, I'm a practitioner. So 2 very, very quick questions. One is about Scope 3 emissions. So it's one thing to consider them in a domestic setting. But can a state make an argument against the applicant based on Scope 3 emissions that take place in a third state and count against that state's emissions under the Paris Agreement? So can it actually make all of these arguments, whether under customary law, treaty law? So that's one thing. And then going back to systematic integration, I was wondering, so we have the ICJ condoning the practice in other fields of law, including and also ITLA. So in human rights treaty bodies, European Court, human rights courts in general, climate is brought in to protect human rights. ITLOS brings in climate obligations to expand the protections of the marine environment. Now, granted, it's not always the case, as Mairee and others pointed out, but in the classic case we're talking about climate obligations to limit the protections of investors. Should that make a difference for tribunals when they consider whether to take into account these types of obligations? Thank you.
Thank you very much. And for the second question?
Okay, my name is Lukas Schauk. I'm with the International Institute for Sustainable Development. I have a question for Arman. Thank you very much for a very interesting panel. So actually two quick questions. The first question is, you mentioned that tribunals would not be raising sua sponte climate obligations, but it would be for the state to raise such issues. I was wondering what makes you say that? And I was also wondering if you could mention any possible reasons why a state, for instance, in the scenario of Rockhopper versus Italy, would not want to raise, even after the advisory opinion, climate obligations, even if the facts of the case relate to a phase-out decision. And in such cases, could it then be a non-disputing party that would raise such an issue, and it could, through that pathway, then become a topic in a dispute? Thank you.
Great. For those, so Arman, maybe you want to have a quick response on those two questions, and then I'll throw it open to the other members of the tribunal if they want to address the first two questions.
The panel?
Oh, sorry, the panel.
Thank you for graduating me.
Yes, thank you very much for the questions. On Iran's question concerning Scope 3 emissions and third states, that's indeed quite an interesting and I would say still open one. First of all, are we settled on downstream emissions as having to be taken into account on EIAs? I think we're not quite there yet, but we're well on our way towards being there. And I'm certainly awaiting keenly the judgments of the High Court of Australia, for example. There have been several proceedings, 4 by my count in the courts below, finding in the affirmative, including the Land Court AO I mentioned for ZEF2, but we'll see what the High Court of Australia has to say, and indeed how much it takes into account the ICJ AO on due diligence, prevention of transboundary harm, etc., and specifically on the EIA question. And there, if that is to be in the affirmative, one interesting aspect of the 1.5 degree question that you addressed in the first panel, and how that was treated in the resolution of the General Assembly, is whether we can still take the 1.5 degree temperature rise standard as a global standard, bringing it to the ISDS context for prospective or forward-looking new investments. That changes the game as well considerably when it comes to then the analysis of the individual state parties' specific obligations with respect to particular emission targets effectively. Though it's a more complicated question than that. And on the two questions put to me specifically concerning why tribunals might not want to raise the sua sponte, that I think I can't answer that scientifically because I haven't done that sort of global survey of how investor-state arbitral tribunals have dealt with the matter. It is something of an open legal question. It's one of those favorite ones that some like to debate in certain, especially proceduralist circles. But I would say, just on a gut feeling, so to speak, especially in a field like this one, if the respondent has not put the argument itself, there are very likely to be reasons internally why that was not done. Certain tactical reasons. So for an arbitral tribunal to sua sponte go into it and to decide the dispute on that basis, particularly in an arbitration context, would be fairly difficult. That said, we've seen arbitral tribunals disregard what, for example, two counterparties have said on the interpretation of a particular agreement. I'm thinking of Ecuador versus Colombia, for instance. And on Rockhopper and states would not want to raise it themselves. Well, Rockhopper, I think, if I'm correct in my interpretation of the underlying facts, the EIA exercise simply didn't take into account really greenhouse gas emissions. So that's actually a rather easier one, though we'll see with Rock Hopper 2, perhaps Italy will take a different approach. In terms of NDPs, we heard this with the first panel. I'm, of course, somewhat colored by my experience with Hacienda, but essentially, I think the interpretation of PO8 is correct, that we were told nothing particularly wrong with what you were putting forward, but we want the respondent to be the one to raise them, particularly when it comes to legal questions and legal issues. So the arbitral tribunal in PO8 cited an earlier PO decision of another tribunal on that point, that specifically NDPs should not be addressing the legal issues. So there, I don't think we can look to most NDPs, so to speak, to be able to furnish what a respondent does not want to furnish for its own reasons. NDTPs, non-disputing treaty parties, might be another matter. Unfortunately, our practice on that is very limited and confined largely to Canada and the United States of America.
Thank you. Does anyone want to address the second question of the first on systemic integration? Mairee?
Sure, thank you. And I just want to make sure that I understand the question correctly, but my understanding is whether systemic integration can apply when the state, in compliance with its climate change related obligation, actually issues a measure that affects the investor's right under the treaty.
Surely it can. I guess the question is, because the context here is limiting protections, should it apply and should it be applied differently? Or should tribunals be more careful when they're applying other laws to limit protections rather than enlarge protections? Should you apply climate change to limit human rights?
Right, and I guess that's where systemic integration would come in, correct? Because you would, the protection of the climate is seen as a protection of the human rights. So how would you really be in a situation where they would come in such confrontation that you would need to pick between one and the, or the...
I'll give you an example. I don't want to miss a debate. What if a state decides tomorrow that every individual can only fly on one vacation on a plane a year because of emissions? And some people would argue that would affect their right to movement under Article 12 of the ICCPR. Should you bring climate change then to limit human rights? It's a different scenario, and I'm wondering if it makes a difference in the approach a human rights body should take or an ISDS tribunal should take.
Yeah, and I guess the reason why I'm having difficulty is because I don't think an investment tribunal would ever be in a situation to assess this way. The tribunal will not assess whether the state is making the correct measure. It will just assess whether the measure that the state took actually violated a substantive standard of protection.
And perhaps, I think that it's a creative and difficult question, but I agree with Mairee that the tribunal might simply refer to whether or not there is a violation of an international obligation, whether customary or treaty-based. But I think that your point is also quite realistic. Take for instance certain communities needing to be somehow affected for the protection of the climate system. I mean, I doubt that ultimately any normal investor-state arbitration tribunal would be fully well equipped to assess that question, because your question is very much related to those that are posed to international human rights tribunals, such as the European Court of Human Rights or the Inter-American Court of Human Rights or some constitutional courts. And what I have seen there is a balancing or a proportionality or balancing of rights. So I'm not trying to give you the answer, but that exercise basically puts on the balance fundamental rights. One would be, in this case, the protection of climate system, and on the other hand, the right of mobility or the right to have their own resources of a specific community. And then they tend to sort of trying to work as an ideal judge, Dorking-led or Hart-led, and see, well, we cannot kill them, but we still need to protect the environment. But it requires some balancing of rights. But I don't think, or at least I haven't seen, investment tribunals do that exercise.
Very, very quickly. Yeah, we are already over time, but yeah.
Yeah, only on that question of framing, I think there is a genuine question that has arisen in the human rights context and in constitutional law context. If you look at the Neuberger reasoning of the Federal Constitutional Court of Germany, the reasoning works precisely that. Is the fear that the court was reasoning around was not how to strengthen human rights with climate change obligations, how to protect human rights from future restrictions on freedoms that are protected by the Constitution due to more drastic climate measures aimed at achieving the same goals of the Paris Agreement. That basically, if you don't act now, you'll have to act much more drastically in the future, therefore you'll undermine rights. And that was the famous intertemporal dimension of fundamental rights that the court added to protect rights from restrictive climate measures. So I think it's a genuine question, and I think perhaps you are only focus on one side of the equation here by saying, oh, we're only limiting investors' protection. No, you are using international climate change law to inform the way the obligations of states, because we're always talking about obligations of states in all of these regimes, the way these obligations play out in specific cases. So it could play out to perhaps inform the police powers. It could also play out to enhance the legitimate expectations of a renewable energy investor. It could play out in multiple ways as long as it informs clearly the content of the different obligations. And I think that is not a one-sided question, is more of a general practice of the way the tribunals might interpret or enrich their interpretation through other sources.
Fantastic. And as I said, we're out of time, but all that's left for me is to thank the members of the panel. And if you could join me in thanking the panelists and the speakers.